The most prominent effect of a Democratic presidential victory would be seen in the understanding of the First Amendment's free speech clause and its application to spending of money on elections. The 2016 Citizens United decision is the most prominent decision that interpreted the free speech clause with effects on campaign spending. But it's really just one of several recent campaign finance decisions where divisions between Republican and Democratic appointees on the court are clear and significant. The particular regulations at stake in these campaign finance cases vary. Questions come up. Can individuals and other groups spend money independently of the candidates? Another question comes up. Can an individual donate money directly to candidates, but adding all these up, can there be an absolute limit on how much an individual can give overall to all the candidates? Well, as I say, these types of particular questions, they vary in the cases that come before the U.S. Supreme Court, but the central question of constitutional interpretation has inevitably boiled down to the following. Should spending money on elections be considered protected speech under the First Amendment? An even more important question, how easy should it be, and on what grounds can government officials restrict election-related spending? Democratic appointed justices on the U.S. Supreme Court have been inclined to allow government restrictions on spending for a broad range of reasons. For instance, they'll say, if it's necessary to equalize political influence, restrictions might be allowed to be imposed. Republican-appointed justices, by contrast, have tended to scrutinize very closely any restrictions on spending. Their view is that spending under the free speech clause can only be restricted for the very limited purpose of combating corruption or the appearance thereof.